Hello, everybody. We'll continue with the Indian Partnership Act 1932, and I'm Dr. G. Mallikarjun. So now we'll see Chapter 6, which deals with dissolution of a firm. So this has sections running from Section 39 to Section 55. The most important aspects as far as this chapter is concerned are the modes of dissolution of firm, then the settlement of accounts of a dissolved firm. So these are and what are the consequences of dissolution of firm also. So the chapter has sections 39 talks about dissolution. So dissolution means dissolving the firm in respect of all the partners. So there is something called as reconstitution. Dissolution means it is totally put to an end. Then section 40 to 44 talks about the various modes of dissolution of the firm. Then section 45 talks about liability for acts done by the partners after dissolution. Then section 46 talks about the partner's rights to have the business wound up after dissolution. So once the dissolution is done, then the distribution and other things which are supposed to be done have to be done. Then continuing authority of the partners for the purpose of winding up is dealt with in section 47. Then section 48 talks about the mode of settlement of accounts between the partners. Then as a continuation of this, section 49 talks about payment of firm's debts and separate debts. What is the sequence of payment? Then section 50 and after that talk about what are the various consequences after dissolution. So section 50 talks about personal profits earned after dissolution. Then section 51 talks about return of premium on premature dissolution, where there is someone who has agreed to being a part of the firm, and before the term ends, the firm gets dissolved, then what are his rights in respect to the premium that he has contributed. Then section 52 talks about rights where partnership contract is rescinded for fraud. So as I told you, the essential elements of a contract are applicable to the contract of partnership also. So where the partnership itself has been created by a fraud, then it can be rescinded, and what are the consequences that flow from it is what is provided for in section 52. Then section 53 talks about restraint, right to restrain from use of firm name and property. Then section 54 talks about the agreements and restraint of trade. So these are the various sections. So first, section 39 talks about the dissolution of firm. Then what are the different types of dissolution? One is dissolution by agreement, where it is provided for in the agreement itself. Dissolution in accordance with the manner provided for in the agreement is section 40. Then compulsory dissolution in certain cases where all the partners become insolvent, or all partners except one becomes insolvent, or that's an event where compulsory dissolution has to be done. Then dissolution on happening of certain contingencies. So when some things happen, dissolution is something which becomes necessary. Then dissolution by notice in case of a partnership of will is section 43. So then dissolution by court is section 44. So section 40 to 44 talks about the various mechanisms of dissolution. Just like you have winding up, voluntary winding up, etc. Here also you have dissolution, one by the agreement, second compulsory, third on happening of certain contingencies, fourth in case of a partnership by will, what is the mechanism of dissolution, then last is the dissolution by court. Then section 45 onwards, they talk about the consequences of dissolution. So now let us see the sections. Section 39. Section 39 talks about dissolution of a firm. The dissolution of a partnership between all partners of a firm is called dissolution of the firm. As I told you, if one partner goes out, two partners go out, then there are people who are retiring. What happens? It's not a dissolution of firm, but a reconstitution of firm with the changes, then incoming partners, outgoing partners. But if the firm is not going to exist anymore after this then that process that happens is what is called as dissolution of firm. So now, first of the things, modes of dissolution is by agreement. So the partnership has been created by agreement. Then similarly, the partnership can be dissolved by agreement. That is, firm may be dissolved with the consent of all the partners, or in accordance with the contract between the partners. So the mechanism of dissolution can be drawn up as a part of the original partnership agreement itself, or subsequently there could be the terms of dissolution that could be drawn up where all the partners consent if they give, then the dissolution will be by agreement. So the original coming together of partners, if it is by agreement, going out can be by the agreement that they have initially done or subsequently based on the consent of all the partners. Then compulsory dissolution. So these are the instances where the dissolution of the firm becomes compulsory or absolutely essential. So first of those, a firm is dissolved by the adjudication of all partners or of all partners but one as insolvent. So the legal capacity to continue in a partnership will be there only when you are solvent. But the moment you become insolvent, you are incapable to contract and hence incapable to be a partner as well. So if all the partners are adjudicated insolvent, there is no issue of the partnership continuing because there is no one with the legal capacity to contract or continue the partnership. Then if all but one are insolvent, you cannot have a partnership of one person. It is a relationship between persons where it presupposes that there is more than one person. So if only one person is solvent and all the other partners are insolvent, then also the partnership has to be compulsorily dissolved. Then second, by happening of any event which makes it unlawful for the business of the firm to be carried on, or for the partners to carry it on in partnership. So in that case also the firm is dissolved. So example, let us take a case where RBI in section 45S of the Reserve Bank of India Act indicated that nobody no firm, unincorporated association of individuals which is doing financial business can receive deposits for the purpose of doing its business. So instead of it being a deposits, if RBI would have given an instruction saying that no person can do the business in the if it is constituted as a firm, then automatically, since this business, which is a regulated business, cannot be carried on by a firm, the firm has to be dissolved. Then the business is something which is possible, but the partners to carry it on in partnership if it is not permitted. So if the firm is prevented from doing non-banking financial business, then automatically the firm for that purpose should not exist, so it has to be dissolved. Then they could say that this business itself, say betting or maybe selling of alcohol. So if prohibition is announced, so whether it is a firm, whether it is a company, whoever is doing the business of selling liquor will have to close their shop. This is a case, this is an example of the first case of dissolution where the business of the firm to be carried on itself is unlawful. An act is passed and the business becomes unlawful, then the firm has to be compulsorily dissolved. Then doing business in the form of a partnership, if that is prohibited, like I was indicating, non-banking financial business not to be done by partners. If there is RBI, if it comes out with any such act or provision, then automatically the partnership has to be dissolved because now it is not capable of doing this business in the form of a partnership, provided where more than one separate adventure or undertaking is carried on by the firm, the illegality of one or more shall not of itself cause the dissolution of the firm in respect of its lawful adventures or undertaking. So imagine that it is doing the business of selling liquor, parallelly it is having a shop which sells this chivda and other things also, which is used for munching. So when the liquor business is indicated to be prohibited, then automatically the liquor business has to be closed. But that does not mean to say that this chivda business also is supposed to be closed. So that business can continue. So the illegality of one or more shall not of itself cause the dissolution in respect of its lawful adventures or undertaking. So the lawful adventure of selling these snacks is not something which has been prohibited or which has been prohibited from being carried out in the form of a partnership. Then those businesses which are illegal have to be stopped. Those businesses which are lawful can be continued. So they can be separated, and accordingly the fate of the firm in terms of dissolution will operate. Then dissolution on happening of certain events. So these are certain contingencies on the occurrence of which the firm can be dissolved. So here says it is subject to the contract between partners. A firm is dissolved. So the contract could have some terms which are different than the general aspects that are provided for here. So subject to the contract between the partners, a firm is dissolved if it is constituted for a fixed term by the expiry of the term. So I say that it is there for 6 months, and on the expiry of the 6 months, automatically the firm can be dissolved after the expiry of the term. Then second thing, if it is constituted to carry out one or more adventures or undertaking by the completion thereof. So suppose there is a firm which is set up for selling refreshments during IPL, and once the IPL is over, automatically the firm can also be dissolved, because the event for which, or the adventure for which they have started that partnership firm, that is now over. So after which the partnership can also be dissolved. Then by the death of a partner also, the partnership can be dissolved, or by the adjudication of a partner as insolvent. So, but by a contract, you could have on any of these instances, you could have alternative arrangements for the continuance of the firm without the dead partner, without the insolvent partner. So those kind of provisions can be made in the contract. Then the next mechanism of dissolution is dissolution by notice. So a partnership by will we have seen under section 7, which says any partnership where there is no indication of any of a duration or determination, then that is a partnership by will. And second thing that is indicated is if there is a term that is there, and after the expiry of the term, the firm continues to still operate, then the firm will be operating as if it is a partnership by will. So in this particular case, the ease of dissolving and ease of partners going out is something which is which makes this an easier process. So where the partnership is at will, the firm may be dissolved by a partner giving notice in writing to all the other partners of his intention to dissolve the firm. So here, one of the partners can initiate the process of dissolution of the firm by giving a notice to all the partners indicating that now we can dissolve the firm. So in which case the firm will be, if they are all agreeable to it, then the firm can be dissolved. Then the firm is dissolved as from the date mentioned in the notice as the date of dissolution. So from which day will the dissolution be operational? So it will be operational if there is a date mentioned in the notice from the date that is indicated in the notice. Otherwise, from the date of communication of the notice, if no date is so mentioned. So if the notice says that that indicates that let us dissolve the partnership from 30th of June. So if the date is indicated, then 30th June will be the date on which the firm will be treated to be dissolved if they are all agreeable. Then the other thing is, if there is no date that is indicated, so when this notice was communicated, from that date the partnership will be deemed to be dissolved. Then dissolution by court. So these are instances where the court will order dissolution and for which an application has to be made. So a suit is filed for dissolution of the firm and accounts. So who files the suit is also provided for in this section. It's an important section, section 44, because it indicates what are the events in which case a suit can be filed before the competent court for dissolution of a firm. So at the suit of a partner, the court may dissolve a firm on any of the following grounds. So one, if the partner has become of unsound mind, then who will file a suit for dissolving the partnership? Either the other partner who is there in the firm, or by the next of friend of the partner indicating that he doesn't want to be subject to an a liability in respect of this firm now since he has lost his mind. So in that particular case, either of these people can approach the court and the court will examine and order dissolution. Then second, the partner has become permanently incapable of performing its duties as a partner. So here, because of some issue if the partner is unable to perform its duties as a partner, and they find that there is no mechanism and you don't want generally him to be held liable. So that's the reason, or you don't want the partnership to be saddled with this kind of a person who is incapable of performing his duties. So the suit can be filed by any other partner. Then, if the partner is guilty of conduct which is likely to affect prejudicially the carrying on of business, considering the nature of the business. So here, the suit can be filed by any other partner. So here, what are the requirements that are there? The partner again who's there in the partnership firm should be guilty of a conduct which is likely to prejudicially affect the carrying on of business, considering the nature of business. Suppose I am doing money lending business, or I am doing any trading business where I am getting. So someone says, goes to the bank and tells that don't honor the checks of this particular partner firm. One of the partners himself goes and tells that. Then second thing is, if he says, go to the other person and then says, don't give him credit because these fellows are all bad. So the carrying on of the business of what is it, financial business or a trading business depends upon this fact that they are able to get some credit, they are able to sell goods, then draw bills of exchange, etc. So if those things are thwarted by the conduct of the person, or he is pilfering money and he is doing any such thing. So doing business with this particular partner or doing business at all is something which is not appropriate. So the other partner will file a suit saying that now you dissolve the partnership firm. Then a partner willfully or persistently commits breach of agreements relating to management of affairs of the firm or conduct of business of the firm. So there are terms of agreement where there are certain duties and rights. Then someone goes ahead and every time that he is interacting, he is breaching those agreements that are there in relation to managing the affairs of the firm or conducting the business of the firms. Then there is no point in the firm, because they will be subjecting themselves to more and more liability because of the actions of this partner, considering the provisions of sections of the chapter relating to relation between partners and the third parties. So any partner who is acting, he is acting as an agent. So why should I have such an agent who is always breaching the agreement? In which case, I will go and file an application and say that now you dissolve the firm. Then a partner otherwise so conducts himself in matters relating to business that is not reasonably practicable for other partners to carry on business in partnership with him. So if he goes on writing complaints to the banks saying that this partner is a cheat, he's spending away money, he is taking away money, your loan will not be repaid, then he is so giving these kind of things where other partners within the business find it very difficult and impracticable to continue the business. So in those cases, what do? You just draw curtains on the partnership firm, for which you will file a suit. So any other partner who is affected by this kind of the conduct of one of the partners will go to the court and apply for dissolution. Then a partner has in any way transferred the whole of his interest in the firm to a third party. So we've seen in the earlier chapter that an interest in the firm can be transferred to someone, but there is an intention for him to come back. In this particular case, there is an intention transfer of the whole interest to a third party. In that case also, if you think that there is going to be an issue with this transfer of interest, then the other partner can file for dissolution of the firm. Or if a partner has allowed his share to be charged under the provisions of Rule 49 of Order 21 of the first schedule of the CPC. So where there is a proceedings for recovery of money, and the share of the partner is also allowed to be charged for the purpose of recovering of these dues under for enforcement of a decree. And these kind of proceedings, if they are there, then also the partnership may be the other partner can go and ask for dissolution of the firm. Then if the partner has allowed it to be sold in the recovery of arrears of land revenue or any dues recoverable as arrears of land revenue due by the partner. So generally arrears of the dues recoverable as arrears of land revenue when you are not paying up government dues, taxes, etc., then there will be a proceedings which will be there, and accordingly a certificate will be issued or something. Then the recovery of that will be taken up as if it will be a recovery of land revenue. So those kind of recoveries that are happening are indicative of non-compliance with law. The court decisions, involving the recovery of money coming in, then a charge being created on his property, and then transfer of the whole interest of the firm to someone else. So these are all indications where the firm could be put to a lot of difficulty, and you don't want one of the partners to be of such a nature that the reputation of the firm also would be affected. So what you would like ideally do is to dissolve the firm and then start afresh. So from that point of view, these are the grounds that could be ground for application, filing of a suit for dissolution of the firm. Then that the business of the firm cannot be carried on save at loss. So if the firm is continuing and it is continuously incurring losses, so the continuation of business that it is going to make profit at some point of time, if there is no ray of hope at all, then what is the point in continuing the firm? In which case they will say that we will dissolve the firm, for which they can file an application before the court. Then on any ground which renders it just and equitable that the firm should be dissolved. So this is an omnibus clause under which if you can't put them in any of the other grounds, you can indicate that there's too much nuisance in terms of continuation of this. So I don't find it, we don't find it appropriate to be continuing this firm. So in the interests of justice and equity, you allow that this firm should be dissolved. Saying this, they will file an application before the competent court, and the court examines the case and orders dissolution. Then liability for the acts of partners done post dissolution. So notwithstanding the dissolution of a firm, the partners continue to be liable to as such to the third parties for any act done by any of them which would have been an act of firm if done before the dissolution. So this is the general rule that is applicable as far as mutual agency is concerned and the liability to third parties is concerned. That is, you are liable from the moment that you are joining into the partnership and till the time the world gets to know that you are no more a partner, or till the world gets to know that there is no, this partnership is not in existence anymore. So how do you keep them informed? That is what is provided. So their liability will continue until public notice is given of the dissolution. So there has to be a notice of dissolution, after which only the liability will be not there. Otherwise, till the time the public notice is not given, liability will continue to third parties for those actions which are done, which form to come within the ambit of an act of firm if it is done before the dissolution of the firm. So here, as in the case of the public notice, again, registered company, registered firms, there are three modes of public notice. That is application to the informing the registrar, notice to the registrar, then notice in the official gazette, and advertise notice in the vernacular newspaper at a place where the firm is, the place of business is located. Then in case of an unregistered firm, it is only the notice in an official gazette and notice in the vernacular. So both these have to be met. If that is not met, you will continue to be liable even after the dissolution of the firm. So then, what are the instances where this liability will not be there is in case of death, insolvency, or in case of dormant partners, like it was there in the retirement or outgoing, incoming and outgoing partners chapter that we have seen now. So those provisions will be applicable. So example, for a person who dies or who is adjudicated insolvent, or of a partner who, not having been known to the person dealing with the firm to be a partner, retires from the firm. So in case of retirement, in case of death, in case of insolvency, retirement not of any partner but only for a dormant partner. So these people are not liable under this section for acts done after the date on which he ceases to be a partner. Then notices under subsection 1 may be given by any partner. So it could be the outgoing partner or it could be any of the partners. Then right of a partner to have the business wound up, winding up after dissolution. So on the dissolution of the firm, every partner or his representative, as against all other partners or their representatives, is entitled to, one, have the property of the firm applied in payment of debts and liabilities of the firm, and then whatever surplus is there to be distributed amongst the partners or their representatives according to their rights. So you have dissolved the firm. Once that is done, then it has to be distributed. It is what is it? Sometimes it is almost like a partition, or what is it? Paying it by meets and bounds. Something like that is referred to. So that is, you are splitting open the whole property, and then you are paying up whatever dues are supposed to be paid, and whatever liabilities are supposed to be paid. They are cleared, and whatever is remaining will be distributed among the partners or the representatives according to the rights, according to the terms that are set in the partnership deed. Then sometimes after the dissolution is over, for ensuring that the liabilities are met for distribution of the property, etc., clearing of debts, etc., you need to have powers to draw checks, etc. So even after the dissolution is ordered, for enabling the winding up process to be over, partners should have continuing authority. That is what is provided for under section 47. It says, after the dissolution of a firm, the authority of each partner to bind the firm and other mutual rights and obligations of the partners continue notwithstanding the dissolution. So whatever obligations are there in relation to the firm, and the authority which is assigned to the partner to bind the firm will continue to be there till the time the winding up process is also over. So what is this? It's not, it is insofar as may be necessary for winding up the affairs of the firm and to complete the transactions begun but unfinished at the time of dissolution. So it is only to enable that the processes are finally wound up with those which have been started at the time when the dissolution process was started. So to give it a logical end, the power is given to each partner to do certain things and bind the firm, and other mutual rights and obligations of the partners will be allowed to be continued even after dissolution. So it's only for the purpose of winding up the firm and to complete transactions begun but unfinished at the time of dissolution, but not otherwise, provided that the firm is in no case bound by acts of partner adjudicated insolvent. So this is applicable generally, but where the person who has been adjudicated insolvent, he goes and does something, then the firm is not bound by that. But this does not affect the liability of any person who represented himself or knowingly permitted himself to be represented as a partner of the insolvent after adjudication. So while this provision relating to continuing authority will not be applicable for binding the firm for the acts of an insolvent, of a partner who has been adjudicated insolvent, if someone claims that he is a partner of the insolvent partner and then he does something, then he will not be, that liability will continue to be there. So this is a principle of holding out that will operate at that point of time. So that way, the liability of the person who has represented himself or knowingly permitted himself to be represented as a partner of the insolvent after adjudication will continue to be there. Then this is an important section, this and the next one, which talks about mode of settlement of accounts between partners. So here again, subject to the agreement between the partners. So you could have an agreement to the contrary, and you could draw up your own procedures relating to settling of the accounts. But if you don't have any modifications that are there or specific rules that are drawn up within this, then the general rules that are there in section 48 and 49 would apply. So it says, in settling the accounts of a firm after dissolution, the following rules shall be observed, subject to the agreement by the partners. What are those rules? First, what is the treatment of losses? So losses could be including deficiencies of capital shall be paid. So losses first out of the profits. So whatever profits are there, that will be used for paying out the losses. Then next, whatever capital is there, that will be used for paying up the money. Then whatever is there remaining, those monies are supposed to be paid by the partners individually in proportions in which they were entitled to share profits. So while paying out losses, the first thing that is appropriated is the profit. Second that is appropriated is capital. And third, if there is any shortfall or deficiency in capital, then the whole money that is required proportionately will be paid by individual partners, and then in accordance with the share in which they are sharing their profits, and then the losses are paid off. Then next, what do you do with the assets of the firm? So the assets of the firm, including any sums contributed by the partners to make up deficiencies of capital. So at any point of time where there is any deficiency of capital, etc., and you have made up the deficiency by payment contribution of money. So how does that assets of the firm and these monies be utilized? So the realizable money that has come out will be used for paying the debts of the firms to third parties. So the first ones who have to be paid out are the third parties. Then second, in paying to each partner ratably what is due to him from the firm for advances as distinguished from capital. So wherever they are doing their business, someone brings in and they have given a loan to the firm, and that loan is the one which has to be taken. If there is only one person who has given the loan, then that loan will be paid. If there are more than one partner who have at periodic times given loans, then in proportion to the loans that they have given, if the total money that is coming out of the assets is not sufficient to meet all their obligations, then proportionately their obligations will be, payments will be made of whatever is remaining after paying out the debts to the third parties to the partners who have given loans to the firm or advances to the firm. Then if the total money is sufficient and still you have surplus, then what do you do is you pay each partner ratably what is due to him on account of capital. So what is the amount of capital he is brought in? Now you have surplus, you have paid out the third parties, you have paid out the loans and advances given by your members fully. Now whatever is there, you try to give it back to the persons who have contributed the capital. If the whole money is sufficient, then you pay up fully and then finish off the firm. But if it is not fully available, the total money that is there after paying out the third parties and the partners for the advances that they have extended, if the money is sufficient, you pay them. If it is not sufficient, then in proportion of the capital that has been contributed by them, you pay it up. Then imagine that there is still more money after paying up the amount of capital contribution also, then the residue will be divided amongst the partners in proportions in which they were entitled to share the profit. So if after paying out the third parties, paying out the loans by partners, returning the capital of the partner, still there is something which is there. That is something which is the residue. That residue, everyone has a share because it is a result of the firm doing business. So that residue is supposed to be distributed amongst the partners in the proportion in which they normally share their profit. So this is the mechanism. So first losses, second assets. Losses first, the losses should be paid out of the profits, then out of capital, and third out of the contribution made by the partners in proportion in which they are receiving their profits. Then the assets of the firms, first they have to be used for paying out the third parties. Second, they have to be used for paying out the advances given by the partners. Third, in paying out the capital contributed by the partners. And lastly, residue distributed among the partners in the proportion in which they are sharing their profits as per the agreement. Then payment of firm's debts and of separate debts. So where there are joint debts due to the firm and also separate debts due from any partner. What is the application of this property of the firm and the separate property of the partner in terms of these. So that is what is provided for in section 49. So where there are joint debts and separate debts. First, let us see what is done with the property of the firm. So the property of the firm shall be applied in the first instance in payment of debts of the firm, and if there is any surplus after that, then the share of each partner shall be applied in payment of his separate debts or paid to him. So if there are joint debts of the firm and separate debts from any partner, so what is done about the property of the firm? So whatever realizable value is there, it will be first used for payment of debt of the firms. Then subsequently, if there is any surplus, it will be used for payment of the share of the partner. And this share of the partner will be applied to clear the separate debts. And if after clearing the separate debts from the share, if there is any residue that is there, that money will be paid to the partner. Then what happens to the separate property of a partner? Suppose someone has got land or some furniture or something. So now you are dissolving the firm. So the separate property which belongs to the partner, which was something which was brought by the partner but was not made the property of the firm. Then first this whatever proceeds are there will be used for the payment of the partner's separate debts. Then whatever surplus is there, that will be used as contribution that he is making for payment of the debts of the firm. So here, whatever he is bringing in will be his. And in which instance will you bring the partner to be contributing this also for the firm? If he is the partnership is not having enough assets to cover the debts, in which case the private property also, whatever is there after clearing the debts, whatever money is there will have to be contributed for payment of the debts of the firm. So these two sections are very, very important, section 48 and 49, which talk about the sequence. It's almost like the sequence of distribution of monies by on dissolution, winding up of a company. What is the secured creditors, unsecured creditors, etc. Whatever sequence is there, that kind of a sequence of payment is what is provided for in section 49 and 50. Then section 50 talks about personal profits earned after dissolution. So subject to a contract between the partners, the provisions of section 16A shall apply to transactions by any surviving partner or by representatives of a deceased partner undertaken after the firm is dissolved on account of death of a partner and before its affairs have been completely wound up. So in case of a deceased partner or the general rule is a partner deriving profit from himself, for himself from the transaction of the firm or using the firm's property or the business connection of the firm or doing it in the firm's name. That profit is supposed to be accounted for and paid to the firm. This is section 16A. So now a partner has died and the surviving partner is there and he is doing transactions. So if the transactions are done by any surviving partner or representative of the deceased partner after the firm is dissolved because of the death of a partner and before the assets have been fully wound up. So they have to be provided for in the manner is section 16. That is, those profits have to be accounted as profits of the firm. So here the dissolution has happened because of the person dying. Then the winding up is supposed to be done and the distribution of money is supposed to be made to the existing partners and the representative of the deceased partner. But in that particular case, if he goes and does anything, then the provisions of section, he's doing the business. The representative is doing the business of in the firm's name or in the name, using the property of the firm or the business connection. Then whatever profit that the representative earns is supposed to come to the firm, notwithstanding the fact that it has been dissolved, but because winding up has finally not taken place. Then provided that where any partner or his representative has bought the goodwill of the firm, nothing in this section shall affect his right to use the firm name. So now someone dies and that partner has, the representative has purchased the goodwill of the firm. That is the reputation of the firm for using the name and conducting the business, etc. If that has been purchased, so there is no prohibition on that person from going and doing, and whatever profits he is earning out of it need not be brought back into the firm because he has purchased it for consideration. That is the proviso to this personal profits. Otherwise, any personal profits made by the representative of the deceased partner has to be paid in, if it is done with the firm's name or firm's contacts or using the firm's property. Then section 51 talks about return of premium on premature dissolution. So here, where a partner has paid a premium on entering into a partnership for a fixed term, and the firm is dissolved before the expiration of that term, otherwise than by the death of a partner, then he shall be entitled to repayment of premium or of such part thereof as may be reasonable. What should be considered? So here, suppose someone has come into, so a firm is doing very well, and then he comes in saying that I want to be a part of this firm, and then he will contribute for coming in. Everyone, suppose if he has paid 100 rupees, then he will be saying that I will be paying 110 rupees or 150 rupees. And we will continue doing this business for say 1 year. And within 2 months, if the partnership is about to be dissolved. So now naturally he has paid a premium thinking that he is going to be there for 1 year. And that premium, what should be done and how the return of that premium is supposed to be done is what is provided for in section 51. So this section will not be applicable where the dissolution is done because of a death of a partner. In any other case of dissolution, this provision will apply. And the other thing that is required is the partnership should be for a fixed term, and he has come by paying a premium. So now how much money of that premium is supposed to be returned? What do you take into consideration is that the regard being had to the terms upon which he became a partner and to the length of time during which he was a partner. So at the time of entering, what is the mechanism of payment that was intended to be made to this person who is joining by paying a premium? Then that will apply. If that is not there, then bearing will also be there on the time for which. Suppose he has been there for within 2 months, it is dissolved, whereas the term for which he was supposed to be there was say 12 months. Then a proportionate premium could be returned to him for the period that he has not been in a position to continue as a partner because of the dissolution of the firm. So now this provision will not apply in 2 instances where the dissolution is mainly due to his own misconduct. So this person who is coming in paying a premium, he is only guilty of misconduct. Then consequently, the case has been filed for dissolution, suit has been filed for dissolution by the other partners. Now, in this particular case, this person will not be eligible because it is his misconduct which has driven the firm to dissolution. The second thing is that the dissolution is in pursuance of an agreement containing no provision for the return of premium or any part of it. So if the agreement itself indicates, or at the time when he has entered itself, it was indicated that there will not be anything called a return of premium, then that there will not be any return of premium. Or at the time when the dissolution is done and the consent is taken of the partners, at that time, if the person has indicated that I am not interested, I won't be, he agrees for not getting any return of premium, then subsequently he can't go back and say that now I want the return of premium because it was supposed to be for 12 months, but now in 2 months and the firm is getting dissolved. So these 2 are instances where the return of premium is not possible, where he is guilty of misconduct, which has in turn resulted in dissolution of the firm, or where there is an agreement to the indicating that he is not, he is agreeable to not have a return of premium. Then section 52 talks about where the contract, the original partnership contract is there, and subsequently one of the partners realizes that this contract is drawn based on fraud or misrepresentation. So then automatically the agreement is something which is a voidable agreement or a void agreement, in which case automatically the firm will be dissolved, because what if the essential aspect of a contract is of a contract of partnership is agreement, and if that itself is vitiated by fraud or misrepresentation, then it has to go. So what will happen to the business that is done, and what will be the position in terms of the persons who are affected by the fraud by being participants in the partnership firm, is what section 52 talks about. So here, where a contract creating partnership is rescinded on the ground of fraud or misrepresentation of any of the parties thereto, the party entitled to rescind is, without prejudice to any other right, entitled to a lien on or a right of retention of. So he will have a charge on or a lien on the assets or surplus or the assets of the firm. So he is contributed into the firm, so he will have a right of lien or right of retention on what? The surplus or the assets of the firm remaining after the debts of the firm have been paid, for any sum paid by him for the purchase of a share in the firm, and for any capital contributed by him. So for the money that has been contributed and for the share that he has taken, whatever surplus is there, he will have a right of lien or retention, right of retention of the surplus or the assets of the firm after paying up the debts of the firm. Then he is also entitled to rank as a creditor of the firm in respect of any payment made by him towards the debts of the firm. So someone as incoming partner, if he is taking up the liability of the previous of the partnership as it was existed when he was coming in, then whatever debts he has paid, he will have a right to be recovering that money and as a creditor of the firm. So that right also he'll have. Then the third is to be indemnified by the partner or partners guilty of fraud or misrepresentation against all the debts of the firm. So this person has created a fraud and he has set up this firm and he has roped him in also into the firm. Then first thing is, now the firm is supposed to be dissolved. So when the firm is dissolved, after payment of all the surplus, all the liabilities, whatever surplus is there and whatever assets are there, he will be entitled to a share. Second thing, if he has come and he has paid up any debts in his personal capacity, so now there is no more firm. So he will have to be treated as a creditor. And third thing is, if because of these acts of these people, if there is going to be any liability on the firm for which he will be asked to pay, he has to be indemnified by the partner or partners guilty of the fraud or misrepresentation against all the debts of the firm. So these three are the rights that a partner who has come into a firm because of the misconduct of misrepresentation or fraud by a party or parties. Then section 53 talks about rights to restrain from use of firm name or firm property. After a firm is dissolved, every partner or his representative, in the absence of a contract between the partners to a contrary, may restrain any other partner or his representative from carrying on similar business in the firm name or from using any of the property of the firm for its own benefit until the affairs of the firm have been completely wound up, provided that where any partner or his representative has bought the goodwill of the firm, nothing in this section shall affect his right to use the firm name. So this is again an issue relating to restraining the use of firm name or firm property. So you could have a contract which may permit a partner or some of or his representative to carry on the business, in which case that terms of the contract will apply. But wherever there is no such a contract, after the dissolution of the firm, till the time that it is totally wound up, nobody can be going and doing the same business in the firm's name or use the firm's property or for his own benefit. So here the principle that you have to you have to pay it back because it is using the firm name, firm property, etc. The provisions of section 16A will apply. If you can't make profit out of the firm's business, though it is dissolved, because it is not wound up, it will continue to be the what is it? The firm will be entitled, and all the partners will be entitled for the profits that you make by using the firm name, firm property. So you can't take personal benefit out of it. That is what is the provision. So they may restrain someone from using the firm name or firm property till the time the firm is completely wound up. However, if anyone has purchased the goodwill, he will have the right to use the firm name. Then the next section is talking about agreement in restraint of a trade. Partner may, upon or in anticipation of dissolution of the firm, make an agreement that some or all of them will not carry on a business similar to that of the firm within a specified period or within specified limits, and notwithstanding anything contained in Section 27 of the Indian Contract Act, such an agreement shall be valid if the restrictions imposed are reasonable. So here, this is something where I am anticipating that this firm now will have to be dissolved. So at the time when I am dissolving the firm, or when I feel that now the dissolution of the firm is likely to happen, the partners may enter into an agreement. What will be the agreement that they will enter into? It will be an agreement in terms of restraint of trade. So this agreement in restraint of trade will be in terms of doing what? Not carry on the business similar to that of the firm. And where should he not carry on the business? Within a specified period. So maybe up to 5 years, you are not supposed to be doing the business. Within this particular localized limit, say 10 kilometers around this firm, you are not supposed to be doing the business. So this kind of terms can be set basically to ensure that someone would be taking over the firm, or the firm would again continue. Someone would be buying the goodwill of the firm. So you don't want a threat from the partners who are going out of the firm after dissolution to be using this. So from that point of view, you could have an agreement for in restraint of trade. But generally, agreements in restraint of trade are void as per Section 27 of the Indian Contract Act. However, this is an exception where you could have an agreement in restraint of trade saying that you can't do the same business within the specified limits or for a specified period. But the prerequisite for that to be held to be valid is they have to be reasonable restrictions to be imposed. You cannot say that you are not supposed to be doing this business forever in this particular area or in any particular area. So whatever you say, it has to be reasonable. So the case which was indicated where we had seen earlier, you say someone cannot do the business. No partner can do the business for a period of 10 years. A doctor cannot do a business of 10 years in a 20 kilometers radius. So that is something which has been held to be a valid restriction. But if the restrictions imposed are unreasonable, then that can be struck down, and it may be indicated that these are not reasonable restrictions. So what you are doing is amounting to restraint of trade, and then Section 27 will apply. So Section 27 will not apply only when the restrictions imposed are reasonable. Then sale of goodwill after dissolution. So while settling the accounts of the firm after dissolution, the goodwill shall, subject to contract between the partners, be included in the assets, and it may be sold either separately or along with the property of the firm. So here, goodwill is an intangible asset. So here it is some reputation that you gain out of being in business. So it's an asset because it has got value, brand name. So what could be done in respect of goodwill is it could be included in the asset subject to contract between the partners. And as any other asset, it could be sold. And it could be sold either separately or along with the property of the firm. We were seeing instances earlier where if the goodwill is sold, so once I am indicating that the firm is going to be dissolved, even before winding up, I can say that the goodwill is sold to partner X. So in which case we can continue to do the business in that name, but I will continue to finalize my accounts for dissolution and settlement. So that's the reason why sale of goodwill could happen separately or along with the other property of the firm. So while selling the other property of the firm, I could also include goodwill in it and sell it and use the proceeds that are coming out of it for paying out the third party liabilities, for paying out advances, for paying out the partner's capital, and finally for distributing the surplus as in accordance with the shares of the partners as per the profit share mechanism. So where the goodwill is sold after dissolution, a partner may carry on business competing with that of the buyer and advertise for such business. So he has bought it, so now he will have to be given the capability of using it. So what he can use for the business, carry on a business competing with that of the buyer and advertise such business. So because the value has been sold, you can't now restrict the other partner from doing it. So another partner of the firm going out also will be now a competitor in the market. So he can go, he can do, unless you have a agreement in restraint of trade saying that he can't do. Otherwise, if there is no such an agreement, he can go and he can do the same business for which he can advertise. However, he is not supposed to do three things. One, he is not supposed to use the firm name. Then he may not represent himself as carrying on the business of the firm. Then third thing is he can't solicit the customers who were dealing with the firm before its dissolution. So subject to agreement between him and the buyer of the partner and the buyer of goodwill. If he has an agreement saying that you can do it, then they can continue to do it. They could have their own arrangements. But if there is no such an arrangement, there is nothing. If and the goodwill is sold to a person, the other partner can do whatever business, the same business he wants to do and advertise it also. However, he cannot do three things. One, use the firm's name, represent himself to be carrying on the business of the firm. Then third thing is whatever customers are there of the firm, you are not supposed to go and deal with them and solicit their customers. So these are the rights of a buyer and seller of goodwill. Then agreements in restraint of trade. So now the first one was in relation to the period between dissolution and winding up. But this one is after winding up is over. So any partner, upon the sale of goodwill of a firm, make an agreement with the buyer that such partner will not carry on any business similar to that of the firm within a specified period or within specified local limits, and notwithstanding anything contained in section 27 of the Indian Contract Act, such agreement shall be valid if the restrictions imposed are reasonable. So any partner may, upon the sale of goodwill of the firm, he can make an agreement with the buyer that such partner will not carry on any business similar to that of the firm within a specified period. So while he is selling, the partner can make an agreement saying that he is not going to be competing there within specified period or within specified local limits. And if the agreement is valid, then the restrictions imposed there. The agreement will be deemed to be valid if the restrictions imposed are reasonable. So these are the various aspects relating to dissolution of firm. So most important aspects being the types of manners in which a firm can be dissolved, that is dissolution by agreement, compulsory dissolution, then dissolution on happening of certain contingencies, then dissolution by notice of a partnership at will, and finally dissolution by court. So then section 48 and 49 talk about the mode of settlement of accounts and mode of distribution of assets for clearing the debts. What is the mechanism for clearing of debts? Then those consequences of dissolution, how do you manage, especially in terms of agreements in restraint of trade, etc., is the other important part as far as this chapter is concerned. Okay, thank you.